Good evening. The Senate Judiciary and House Child Welfare Conference Committee. And there has been a proposal from the House, which we are reading on. Oh, there we go. Should I start over? The Senate Judiciary and House Child Welfare and Foster Care Conference Committee will come to order. When we last met earlier this afternoon, the House had provided some proposed amendments to Senate sub for House Bill 2070, which includes the Office of Child Advocate in it. And I think we were waiting for the reviser to make balloon amendments, which are prepared. So wonderful. If you want to pass those out, that would be great. And before we get to these in detail, did appreciate the explanation as you went through those earlier. Do you want to have the reviser explain, or would you like to?
I'll let the reviser go through these. She's available. Thank you.
Thank you, Madam Chairs. So the balloon that was offered and described at 3:30 today is included in the materials in front of you. So the first change is on page 2 in line 4. It includes the qualifications of what a child advocate shall be in order to be appointed. That includes a relevant license that would authorize an individual to work as a licensed professional in a behavioral health setting as an attorney, or has 7 years or more of experience in the field of child welfare, or has demonstrated extensive experience in the practice of child welfare in the field. And this language is taken from the as amended version of 2443. What you see in lines 17 and 19 is the salary amount is struck. On next page 3, in line 5, you have that parent B struck in regards to receiving and resolving complaints about the mental health, safety, welfare of child, or failed to follow established laws. It retains the child advocate shall, and therefore retains the 1, 2, 3, 4, 5. Following that, under parent C in line 40, you have capital 1 or capital C is struck there, and so that's striking that kind of records and public access aspect. Page 4, in line 11, you're striking. I apologize. In line 11, that 4, you see the lines 11 through 16 have also been struck, and that is related to access to records again. And then line 20, you have that subpoena power struck in this balloon. And then at the very bottom, you have the beginning of D5 about producing reports of findings of fact, and that the Attorney General may file such reports in a pending child in need of care case on behalf of the office. So that is struck, and in its place is proposed the court interactions that you can find in House Bill 2443. And those include filing the office's findings or reports and issue recommendations regarding the disposition of an investigation to the court and to an investigating agency, but that the child advocate shall not intervene in divorce, protection from abuse, juvenile offender, or SINC cases, administrative hearings, or civil or criminal proceedings. It gives the Office of the Child Advocate the power to file an amicus curiae brief and in appeals from child in need of care matters. And then lastly, to utilize resources from the AG's office as necessary to carry out duties in the section. Page 6 is line 9 through 12 is struck, and this strikes another reference to accessing records. Line 24 is new section 4, and you can see that parent A is struck. And this also relates to information obtained and the confidentiality aspect. And then the next, it attempts to shore up that in it keeps the B language and inserts in accordance with the requirements of KSA 382201 and 382301 at SEEK. So that specifically references all the confidentiality requirements that already exist in law and are being amended later in the bill. Line 36, you have parent C that is struck, and this relates to taking away the requirement that communications of anyone to the office be privileged. Next, you can find on page 7 that it strikes parent E, and this relates to the office disclosing the final result of an investigation with the consent of the child or the child's legal representative, and that is struck. And that is what can be found in the balloon in front of you.
Thank you for the explanation and putting that together. Appreciate that. It's a lot to digest and a lot to take a look at. So understand some of the concerns regarding or some of the differences regarding the qualifications for the child advocate, looking at the salary, looking at the subpoena power for the child advocate, access to records. Tell me on page 3, line 40, that's stricken, all records of any public or private agency or institution. Those are just public or private agencies or institutions having custody of the child. Or actually also provides education, medical, or mental health services to the child. So that would be a public or private school as well, and a private doctor as well that would be subject to the records being subpoenaed. Do I have that right? Or are those not subject to subpoena? Because the subpoena materials or witnesses on page 4 later in the bill, but would still nonetheless apply to private agencies regarding education, medical, and mental health services. Do I have that right?
Madam Chair, that language struck in C in line 40 relates to access. They just have access, but then that is also something that could be subpoenaed under the current language.
And the purpose of the balloon on page 5, the difference in striking subsection D5 and inserting the balloon, what's the policy behind that? Page 5, the balloon on page 5 that replaces the struck language at the bottom of page 4 and the top of page 5. D5, section 3, D5.
So our discussion was that replace language with the language, the House language. Oh, that was the one that we were looking up on the comparison chart. And that we felt that information is too broad. No, wait a minute. Lost it.
That would take us to the House position. Is that what you're
It
saying?
takes it to the House position. Our language is more detailed and provides additional clarity.
Okay, thank you. Are there questions for the reviser regarding any of the amendments? Well, this is a lot to digest, so we will look at this this evening and overnight, and we'll be working with the reviser to maybe find some middle ground on some of these issues between the Senate position and the House position. I think the Senate position is that the child advocate shall have subpoena authority, and the House position was to take that out completely. Is that correct?
The House position is to not have subpoena power, but it itemizes, it lists all of the different files and records that they would have access to.
So again, just probably going to visit with the reviser and see if we can find some middle ground to work with to get something in place. So are there any other comments or questions? Not.
Just as a reminder, as far as middle ground, we gave a lot of Senate position in this as well. So,
Right. Appreciate that. And it's always just a negotiation, right? So appreciate it. I'm going to take just a break here for just a second. So thank you, and let us work with the reviser, and we'll have something to propose, not in the morning, because we are on the floor at 10 o'clock, each of us. I'm not able, due to family commitments ahead of time, to be here. And upon recess of the second chamber, I am meeting with corrections tomorrow. So should we pick a time, or what's best for you?
so we are meeting with Senate Health at the first recess.
Okay, good. And we're meeting with
10:30.
corrections at first recess.
Oh, first recess. Okay.
First recess after the second chamber recesses. And so should we try 1 o'clock again?
Works for me.
We'll try 1 o'clock again. Okay, so 1 o'clock and room to be determined. So, okay, great. Well, thank you very much. Appreciate it. We are adjourned.